This morning on the Ag Issues program. A pleasure as always to bring back to the program, as we do every couple of weeks, Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thanks.
Curious, up at your farm, how much snow, or I'm assuming it's still snowing. How much snow did you guys get?
I'm not quite sure. I poked my head out earlier this morning, took a couple pictures, but didn't bother to go out into it. Actually, to me, it doesn't look like that much. So I don't know. But I'm always tainted. I grew up in the snow belt in northern Indiana, and when you have back-to-back winters of 130, 140 inches of snow, getting 5 or 6 inches is nothing.
Yeah, exactly. Most definitely. All right, let's get to it. And we're looking back at some of the important developments that we have seen as far as ag and tax law cases are concerned. And let's first start out looking at some of the labor disputes in agriculture. And the first one you start out with is the case of Glacier Northwest Incorporated versus the International Brotherhood of Teamsters Local Union 174.
Yeah, this is an interesting case, Greg. It's not an ag case on the facts, but it has implications to ag, and went all the way to the U.S. Supreme Court, resulted in an 8-1 decision. And what it is you had workers at a concrete company that filled the mixer trucks with concrete ready to pour, knowing that they were going to walk away. And the company sued directly. They went to court. They didn't go through the mediation process, the arbitration process, the administrative process established by the National Labor Relations Board. They didn't go through any of those procedures. They went straight to court. And, of course, the union said, well, you can't do that. You got to go through all these labor law procedures. And the court said, no, you can go straight to court because they're suing for damage to their property. That is not protected by federal labor law. And the court said this is more just like an ordinary tort lawsuit. It's not a federal labor dispute. So that's why the company could go straight to court, because as the U.S. Supreme Court said, walking away in that instance was inconsistent with accepting a perishable commodity. And there, I think, is where the tie is. Maybe not so much for our products that we raise in the center part of the country, in Kansas included, but in the fruits and vegetable regions. That's an important point, because where there are labor disputes in agriculture, they're often timed to damage perishable food products such as fruit and veggies. So I think, based on the court's opinion, if workers or a union is timing a work stoppage during harvest, that might not be enough to be deemed economic damage unless the union has a contract. But if you strike after a sorting line has begun, that would seem to be enough now, and the company could go straight to court.
Another part, or another thing we want to go to, and oh boy, how many times have we talked about this? The case is Foster versus the U.S. Department of Agriculture, but it has to do with Swampbuster rules.
Yeah, this is a farmer in southeast South Dakota, kind of in that rich farmland belt there north of Sioux Falls. And his father planted a tree belt back in 1936, and that tree belt developed as it was supposed to over the years, and it would bank snow up, keep it off his lanes, keep it off the roads, keep it out of fields. But then sometimes in the spring, there'd be a sufficient amount of snow that would thaw, and that snow would pond and form a puddle of less than an acre in the middle of a farm field. Didn't drain anywhere. It was just a puddle, and it would eventually dry up. But long story short, he got ensnared in the Swampbuster rules, and the USDA took the position that that was a wetland under the Swampbuster provisions, and therefore he couldn't farm that field. They had to farm around that puddle in order to keep his farm program benefits. Otherwise, he'd have to forfeit his farm program benefits. And he challenged that determination in court, lost, but then used a provision that Senator Grassley had drafted and got in the law a number of years ago that said that a farmer has a right to challenge a determination by USDA when they have evidence that the government hadn't considered previously. So he comes up with all this additional evidence of soil types and comparable land and all types of things that were not considered the first time the USDA made its decision, and the USDA refused to reconsider it. So he went to court. So far he's lost, but now He's filed a motion or a request with the U.S. Supreme Court. He's filed a cert petition with the Supreme Court for the U.S. Supreme Court to hear the case. And in 2024, the Supreme Court will decide. They didn't do that just earlier this week. They had a conference date, and I didn't see it on the list. So we still don't know yet whether the U.S. Supreme Court will take the case. But when you have a wet area that doesn't drain anywhere, that's not subject to the Swampbuster rule. So I think the courts are wrong on this, and I hope the Supreme Court clarifies this.
Another case that is out there and familiar to many as well, you look at abandoned rail lines that you start to see more of them that are converted to recreational trails, and it has definitely been controversial, but the rails to trails cases came up also in 2023.
It sure did. And this was a decision by the U.S. Court of Appeals for the Federal Circuit involving Missouri law. It seems like over the years we've had a number of these rail trail cases come out of Missouri. Kansas has had a couple of them, but the more prominent ones have involved, of course, the Katy Trail in Missouri and other trails in the state of Missouri. But what you had here was a rail line that abandoned its line, and it got converted into a recreational trail instead of reverting back to the adjacent landowners along that line. And that raised a question as to whether there had been a taking by the government here under the Rail Trails Act, whether those landowners should have been compensated for the loss of that corridor that was adjacent to their property, should it have reverted back to them. And the court said, based on the original grant to the railroad and what the purpose of that grant was, that there was a taking in this instance because the railroad was only granted an easement. They did not have a fee ownership of that corridor. They had an easement, and the terms of the easement said it was for railroad purposes only. Well, a trail is not a railroad purpose, and so the court said there's a violation here. That land should have gone back to the adjacent landowners. If you're going to put a trail in, then you have to compensate those landowners. So it was a compensable taking under the Fifth Amendment.
And one other case before we go to, well, actually do two other cases before we go to break. We talked about rails to trails. Another one that comes up, and how many times we talked about certain cases about this, confined animal feeding operations, better known as CAFOs.
Yeah, this was a development in 23 involving medium-sized CAFOs and going back and involving a USDA rule in the Obama administration in 2016, where they said, well, we're not going to hold them to any type of environmental rule for them to get an FSA loan. So they said, no, you don't have to do any environmental review on these medium-sized CAFOs. And now, to put this in scope, a medium-sized CAFO can house up to 700 dairy cows, 2,500 55-pound hogs, or up to 125,000 chickens. And so the government was saying, the Obama administration was saying, no, even if you have 125,000 chickens, you're not subject to any environmental review if you want an FSA loan. Well, a number of farm groups challenged that, and they got that rule thrown out. The court vacated the rule. And the FSA conceded in that instance it made no finding as to environmental impact. They just blew off the entire requirement under another provision of federal law. And the court determined that was fatal, along with providing no public notice that it was going to just categorically exempt all loan actions to medium-sized CAFOs. So that was a big development in 23. I don't expect that to be over. I think in 24, before the fall elections, it's likely that the agency will try to exempt those medium-sized CAFOs from environmental review for FSA loan purposes.
And another case that came out in 2023 concerns the charitable remainder annuity trust abuse.
Yeah, we had a case in 22. We had another one in 23. It was a full tax court opinion in 23. And what this stems from, Greg, is an advertisement that this group out of Columbia, Missouri ran saying that basically you could solve all your tax problems with a charitable remainder trust. They put it in the High Plains Journal, and they were targeting farmers. And it had a lot of incorrect information in it, a lot of misinformation in it. And it snagged about 70 farmers, and there were about $14 million of unpaid tax. And the Department of Justice, the IRS Criminal Investigation Division, swooped in, turned it over to the Department of Justice, and all these players in Columbia, Missouri, and a couple of associated law firms, an annuity selling firm. These were in different parts of the country that was tied into this, plus an attorney out in San Francisco that was tied into this. Now, she wasn't prosecuted, but the other players that were promoting this, the promoters of this, were all prosecuted, and they had to disgorge those funds, and they have been banned from promoting this concept. Now, a charitable remainder trust can be a good tool. It's just that they were misleading farmers in saying that you could put your crops in it and get a charitable deduction. You can't do that with a raised crop because you don't have any basis, but that's usually not why we set these up for farmers. There are other reasons that we do that, and it's a good concept. It's just you had people that were not doing it right here.
Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, is our guest on the program. And going to also talk about another thing that we have seen several times or talked about, the Packers and Stockyards Act, in this case, talking about the scope of the dealer trust.
Yeah, this was an amendment to the Packers and Stockyards Act enacted in late 2020, and its purpose is to protect unpaid cash sellers of livestock from the bankruptcy of a feeder, a broker, or a small processor. And so what it does is it puts unpaid cash sellers of livestock ahead of prior perfected security interest holders. So it's a provision like the trust that already exists for unpaid cash sellers of grain to a covered grain buyer. So the first case that tests the scope of the Dealer Trust Act started through the courts in 2023, and what it involves, and there's numerous cases that are tied into this. It involves over 100 livestock producers that have $122 million in unpaid claims against 3 defunct cattle operations, and a lender, also a big ag lender, says one of the feed yards sold about 78,000 head of cattle and didn't pay on the loans. And so these feed yards got into a Ponzi scheme that totals about $175 million to the extent we can tell, and a check hiding scheme that the feed yards were engaged in. And so the issue is, what's in the trust? What are the assets in the trust? Is it all of the debtor's assets? And for a feed yard and a cattle operation, it could be, because practically all of their income comes from cattle sales. So we shall see in 2024 what the court says in terms of the scope of that new dealer trust provision.
Another part that many look at, of course, is their equity, and especially for a homeowner in their home or farm, most definitely is something to keep an eye on. But in this case, we're talking about equity theft.
Yeah, this is a case that also went all the way to the U.S. Supreme Court. It was a unanimous decision by the Supreme Court, and it stemmed from a homeowner up in the Minneapolis area that failed to pay property tax, and the county came in under the existing state law procedure and sold it was a condominium, sold the condominium at a public auction, and then kept all the proceeds, even beyond what the tax debt was. Just didn't remit any of the remaining balance back to the homeowner. Just kept it all. State law allowed the county to do that. Well, it eventually gets to the U.S. Supreme Court. The U.S. Supreme Court says, no, that's a taking. You're entitled to recover the property taxes that are due, but the balance that was received at the auction goes back to the homeowner. And this is a big issue, Greg, because the same thing had happened in Massachusetts with respect to an alpaca farm. It also happened in Nebraska with respect to a ranch near North Platte, because there are 12 states that have statutory procedures that allow a state to keep the equity. Now those states are going to have to change their laws. But that was a big development, and that was a U.S. Supreme Court decision in 23.
Roger, it's not often that, I don't know if we actually have, talking about customer loyalty rewards. In this case, we're talking about a case that involved the Hyatt Hotels Corporation.
Yeah, it involves Hyatt Hotels, but the principle here is applicable to ag businesses too, and ag retailers. You just think of all the businesses that you buy products from. Many of them will have a reward program. They'll ask you at checkout, well, do you have rewards? Well, yes. Well, you can build up points, and then you can redeem those points. So you go to the gas station, or in this instance, you go to a hotel, you build up stays, you fly on an airline, you build up miles for a free flight. The question here is whether the parent company that is the party that is responsible for the fund in which all the retailers and all the businesses pay into the fund and then are compensated out of the fund when a customer redeems the reward points. The question is whether that parent company is treating that correctly from a tax standpoint. Hyatt Hotels was not. They had created a fund many years ago for participating hotels to pay into and then be compensated from. And of course, they managed that fund. They controlled that fund. They invested the proceeds in that fund. They made money off of it, but they didn't report any of it. And the tax court said because of the extent of control over that fund, Hyatt Hotels is responsible for reporting that in income. I have a feeling, Greg, that a lot of ag businesses, maybe the parent companies, are not doing this properly, and the Hyatt Hotels case is probably just the tip of the iceberg. And now the tax court has put its foot down and said, this is the way this needs to be done, and companies that have customer loyalty reward programs need to follow that.
And as we wrap this up, talking about a particular case, in this case, that looks at the basis of assets contained in an intentionally defective grantor trust.
Yeah, this is an interesting concept known as an IDGT, an intentionally defective grantor trust. And some people would say, well, why would I want a defective trust? Well, it's got language in it that says that while it's effective from an estate tax standpoint, it's an irrevocable transfer away from you into your trust. That keeps it out of your estate at death, but you still pay the income tax on any income generated by the assets in the trust. And some would say, well, why would I want to do that when I transfer the assets away from me? So that those assets will build up a tax-free wealth for the next generation. And it's a concept that we use in farm and ranch estates, the larger farm and ranch estates in particular. And the question has been, can I still get a basis step up at the time I die of the assets in the trust in the hands of my beneficiaries? That's very important to them. So if I transfer farmland, farm assets, low basis assets into the trust, keep them out of my estate, I still pay the income tax on it. Is that retention of the obligation to pay income tax enough to cause inclusion in my estate for basis purposes in the hands of my heirs? And the IRS, this has been a confusing thing for the IRS for 15, 20 years. And finally, in 2023, they said no basis increase. And I won't get into the details of that because we don't have time. But we're going to have to rethink some of the planning with respect to intentionally defective grantor trust. We won't be able to get a basis increase in the hands of the next generation.
All right. And of course, this is going to lead up here next couple of weeks as we go over your top 10 list. But if people want to read more about this, they can go to your blog.
Yep, it's posted on my blog. It's also shared with Ag Manager over at K-State, and people can also find it on my blog on RFD TV.
All right, sounds good. Roger, as always, appreciate it, and look forward to going over that top 10 here in a couple of weeks.
Thank you, Greg. My pleasure.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he's been our guest on the Ag Issues program here on 580 WIBW.